Welcome to this lunch session. We are going to talk about a whole host of issues, although the title of the panel says, is it really going back to going dark? So the center around which we will anchor this discussion is going to be on encryption. But as the panelists themselves have indicated to me, they are going to presumably cover a broader field of issues, but we will try and be true to the spirit in which this panel was curated. And I'm going to introduce the panelists as and when they speak. The idea is that each of them will hold forth for 4 to 5 minutes, after which, given the capacity and the interest in this subject in this room, we are going to open it up for 30 odd minutes or more. I'm going to start from my right and move forward. And I'm going to request Joanne to open the discussion today. The idea behind this conversation is to take note and discern the trends that have taken place, especially in this part of the world, in Asia, with regards to encryption, the regulatory impulses that have determined which direction an encryption policy is taking place, which direction the encryption policy in places like India are going, what are, whether that regulatory impulse is security, economic, political, so on and so forth. And we have a distinguished panel that is able to cover the field in as comprehensive as a way as possible. Joanne is from the National Cybersecurity Agency of Singapore, where she is a manager, and she and I were having this conversation about the architecture that Singapore has in place, which is quite sophisticated, which in some ways resembles what India has, and in some ways does not. And many of you would have known the cyber attack on Singapore recently. Although, as I said, the subject is encryption, we will talk about a lot of subjects that implicate national security, implicate privacy. But without any further delay, let me hand it over to Joanne.
Oh, sorry. Yeah, so thank you for having me on this panel. I think the first thing that I would like to talk about with regards to the going dark debate is whether or not data is indeed going dark. Being from a cybersecurity agency and from the cybersecurity angle, it's very hard to protect data. So a lot of the conversation has generally been about data that's in transit, end-to-end encryption. But this kind of protection is very limited in nature. There are many other weak points that you can attack from a cyber attacker perspective that you can access data from. So there's like data at rest. And people have tried to explore encryption of data at rest. So of course there are many organizations that do it, but it still poses a significant challenge in terms of cost and usability issues to encrypt your data at rest. And then there's also other places that you can get the data, for example, metadata. And I was just sharing with Arun earlier that, when an investigator typically goes down with a warrant to investigate somebody, they could just sit down next to the person and scroll through the WhatsApp chats. And when your own WhatsApp data is backed up, it's not encrypted when it's on the cloud. So, and related to the cloud issue, we need to think about like future developments as well. So when there's a very strong push to move a lot of things onto the cloud, and if encryption at rest is very difficult in internal systems already, like moving to the cloud is going to pose new challenges. So, and then you also have to think about quantum computing, which can threaten a lot of encryption. Right now, of course, they are still looking through the different algorithms and what might work and what might not work that could be resistant to quantum computing being able to decrypt it. But it's still a challenge, and we do not know yet whether it's going to impose a lot of costs for encryption at rest. So, in my opinion, at least from where my standpoint is, I feel that data is probably going bright rather than going dark. And perhaps the challenge is whether governments can be innovative and adaptable to think of creative ways to access the information that they need for national security reasons. And I feel that when it comes to this issue, perhaps a lot of the debate, at the crux of the debate, is the debate between privacy and security. In my view, it's a public trust issue, and it's about the social compact between the government and the industry. And it's not just the government and industry. I think it's important to know that there are also other actors involved. There's like criminals, of course, and terrorists. So with these three groups of actors, it's like a triangle, if you will, and trust is a trade-off. When you disempower one party, you necessarily empower another party. You can't talk about them in isolation. And of course, we also know that with tech, consumers themselves and users are also more empowered. So tech has disrupted a lot of the existing social compact and existing power balance. For example, in the past, the government used to have a lot of the data because it provided the public service. So people would go to the government as a single point of contact to get, to register like marriage, residential information, a lot of personal data. And the government used to have a lot of this data. But with the rise of big tech, a lot of these big tech companies know a lot more, far more about the individuals through even more data points than many governments out there. So you could say that the power balance has perhaps net-net shifted towards big tech. Yet, when we talk about this particular issue, a lot of the awareness seems to be about government snooping, about government intruding on privacy, and I think it has to be put in perspective in terms of like how the government has ceded some influence to tech companies, and also how criminals are being empowered. As an example, like a lot of people, when they talk about this issue, yeah, it's being addressed, but then when you look at their own cyber hygiene, like basic cyber hygiene, like not using bad passwords, using two-factor authentication, not clicking on the phishing email link, a lot of the times people still fall prey to it. And what happens is they become victims of, say, financial crime, and they end up funding these criminals which they did not democratically elect. So I think we need to be aware that we are not binding the hands of a party that we have chosen for a party that we have totally no sight of and do not trust at all. So what I think is needed is a societal discussion on perhaps an updated social compact. So when it comes to governments, do we still trust governments for national security reasons? And can governments remain agile and innovative vis-a-vis the tech giants? And when it comes to the tech giants and business and industry, do they need to perhaps step up a lot more in terms of public interest? So we are beginning to see this like with the Tech Accord, and also there was this open letter between 2015 and 2017 by many industry members to urge the governments of the world not to weaponize AI. Those are positive examples. Perhaps another question to consider is, the corporate governance model is very focused on the stakeholder. But with tech giants becoming so influential, do we need to ask whether or not it should be a more community-centric governance model, perhaps? And indeed, when tech giants are a lot bigger, it also becomes in their own interest to protect the community, to make the community a sustainable one, and to create a sustainable ecosystem. And then we should not forget that the consumers and the users themselves are also responsible for considering not only cost and usability issues in their purchases, because every dollar that they spend on tech giants is giving them influence, and not only do they need to vote responsibly in, say, elections, but perhaps with their dollars as well, that they should be more responsible with it. So with that, yeah, I'll pass the time on.
Thanks, Joanne. Let me now go to Manish Tewari, who is a former Minister for Information and Broadcasting in the Union Government, former Member of Parliament, and an influential voice in these matters. And let me pick up a question that Joanne said, which is, by way of background, many of these technological debates, these debates on technology that we're having today in India, were seeded at a time when Mr. Tewari was at the front and center of policy making. So I guess this is also a time for us to ask many questions to him, keeping in mind that he was at the forefront then, and he may well be at the forefront of, say, drafting a new encryption policy with elections around the corner. Let me pick up a question that Joanne raised, which is, should we be trusting governments on issues of national security?
My colleague, Mr. Panda, Joanne, Wong, if I get the pronunciation right, Arun, Mohan, Sukumar. Ladies and gentlemen, it's always a bad idea to interrupt people's lunch with a boring monologue, howsoever interesting the subject may be. to commence with Sukumar's question, should we trust governments on national security? I think it's a completely false binary. Let me caveat that by saying that I speak for myself and I do not speak for the party that I speak for 24/7. And the reason why I say that is because when I read the subject of today's panel, essentially data localization and de-anonymization, and I went through the report of the Sri Krishna Commission. We had a whole commission which went into the issue of data protection. And of course, they also came out with a draft law. The one thing which struck me very clearly was that there is a huge dichotomy. Governments still continue to live in 1648 while we are in 2018. And I think why 1648 is important is because that's when the Peace of Westphalia came about. And the Peace of Westphalia really gave the conception of sovereignty. And what really was that conception of sovereignty? That there would be no uncontested spaces in Europe, essentially to ensure that conflict could be mitigated, if not completely eliminated. And to the credit of the Peace of Westphalia, it held till the Congress of Vienna, and the Congress of Vienna renewed in 1815, and it held till the First World War, and then after the Second War, you had a new reality. But the conception of Westphalian sovereignty has remained frozen in time. And therefore, states find it extremely difficult to deal with a post-Westphalian reality, which is the internet and the social media. And since states are completely and absolutely allergic by reflex, instinct, and intuition to let go of control, when they are confronted with the reality that there is a huge ungoverned space called the internet, which is completely and absolutely out of their domain, they are flummoxed. And so the natural instinct is, we must try and bring it under control. And the reason why they're able to succeed to some extent is because what you see is the flora and fauna of the net. But the underlying hardware, the routers and the cables and the gateways, the physical infrastructure of the net, still continues to be under regulatory oversight or intrusion of states per se. And so therefore, if you are China, and with great respect to any Chinese delegates in the room, you are able to convert the internet into an intranet by effectively firewalling it. But that does not prevent a million mutinies on the net on a daily basis. So this whole mindset of data localization is a completely Westphalian mindset which is not able to comprehend that you're living in a new reality. And so therefore, when you have people who have been institutionalized in those mindsets, trying to write reports, and with all great respect to Justice Sri Krishna, was being a great judge of the Supreme Court, I don't think you are really able to comprehend what you're dealing with. And so to me, I think data localization is a complete non sequitur. What you really require are protocols whereby you can have an effective sharing of information in case there is a critical challenge to national security or law enforcement. And even the barriers of accessing that criticality need to be very clearly laid down. And the bar needs to be set very high. Because states instinctively have a desire, if I can use the word, to abuse that discretion which is available with them. So I, for one, speaking for myself, I don't think this data localization is a very great idea, that you need to have a copy on a server which is located nationally, and there need to be filters, and there need to be kind of protocols on the kind of data which can possibly flow out. I think it's just the inability of people to be able to get out of that Westphalian mindset. On de-anonymization, as someone who's at the receiving end of bots and trolls and all kinds of nefarious characters in the social media space, often not real, but machine automated, I still very strongly support anonymization. And the reason why I support anonymization is because anonymity is perhaps the only way available to freedom-loving people around the world to fight tyrannical and despotic regimes. And so therefore, when you are confronted with a situation whereby you are struggling for those basic rights or those natural rights which should not be denied to any human being, and the response of the state to that fight is to try and physically liquidate you, or at least throw you in the can as far as, for as long as possible, anonymization is an extremely efficient way of fighting a tyrannical and despotic state. And that's why I say that this entire binary of national security vis-a-vis privacy is completely a false binary. And that's why the Supreme Court of India demolished it very effectively, when in a unanimous judgment of 9 judges sitting together, which is usually unprecedented in our Supreme Court, I'm a lawyer by profession, said that right to privacy is a fundamental right. And in fact, the judgment went further to say that the right to privacy includes the right to be forgotten. So therefore, when you have the judiciary weighing down so heavily in favor of the individual or the citizen, the reason they are doing that is because they're extremely cognizant of the very mischievous ability of the state, which gets reflected in these attempts or in these very subtle drafts called data localization and de-anonymization, etc. You've already must have heard a lot about Aadhaar. It must have been coming out of your ears by now. I, for one, have always been a critic of Aadhaar. Even when I was in Parliament and even after that. And I fundamentally believe that the state has no business to have control over the proprietary data of millions and millions of citizens. And I think with all the right intentions when we began in 2007, and it began during the time of our government, I don't think the intent was wrong. But what was offered was the panacea of a magic number, which would unlock the gates to heaven. Suddenly you would have every goods and service, all goods and services available at your fingertips. And I think somewhere what got lost was the whole doctrine of informed consent. That what really are you giving up for this Shangri-La, for this promised land? And if given a chance to redo this whole paradigm, I think at some point in time the Indian state, and it's going to be a very difficult consensus to build, because Aadhaar has definitely empowered people who were faceless or nameless, and as people who've been in Parliament, fought elections, represented people, you've seen the empowerment on the ground. But the idea of the state being in control of so much of proprietary data makes me very uncomfortable. I would have been happier if the individual was in control. and could have used it at his discretion to access whatever he wanted. And I will close by saying, you see, for all those who are advocates of free speech, who are advocates of a free internet, I think the greatest danger to free speech and to a free internet is from them. And the reason I say that is because till the time you do not have agreed rules of engagement emerge in the virtual civilization, till the time stakeholders, rather than stymieing those talks, actually do not arrive at a modus vivendi, sooner or later you will have states stepping in. And when states do step in, they do it with a very heavy hand. And I'll leave it at that. Thank you.
Excellent. That is some strong stuff, and keep in mind keep those in mind while you prepare your questions for Mr. Tewari. Just to pick up on the point about data localization being a concept that emanated from the Peace of Westphalia, I think I'm glad that he brought it up, because although the decisions are indefensible or they can't be justified, the fact is that when it is imposed, when a data localization is imposed as a policy in countries like India and China and Russia and so forth, it is typically seen as something that is flowing from this part of the world, whereas, as he rightly pointed out, the impulse comes from 1648. In fact, the data localization impulse that characterizes much of modern for the last 10 years came from the 2008 financial crisis. The first data localization policy came out of the financial crisis in 2008 through the Dodd-Frank Reform Act, when regulators of the Securities and Exchange Commission realized they did not have access to data by the Lehman Brothers, and it was stored somewhere in servers in Europe, which is when US regulators decided that it was time to have a copy of data located in US. That, as he said rightly, that does not defend decisions made in this part of the world, but thank you for drawing the historical lineage of those sort of policies. Let me now turn to Baijayant Panda. Mr. Panda is also a veteran of Parliament, a 4-time MP if I'm not mistaken, but more importantly, somebody who is extremely involved in debates around the space. And to paraphrase Mr. Tewari, somebody who also believes for the state to let go, but in a very different way. He has been an active advocate of freer enterprise, but the challenge which I now pose to him is, once you are dealing with the proliferation of data, especially in the private sector and by public agencies, how are you going to balance this dichotomy that he said of privacy and security? So over to you.
Thank you. This session is supposed to be broadly about privacy versus security, and with some conversation about encryption. So I'm going to start off by making a passing comment on encryption and then focus on this, the broader issue. So on encryption, I have a message for the good people at ORF. You know all those times you tried to call me and you couldn't get through to me? Next time, try calling me on a voice call on WhatsApp. Many people that I know today will not discuss anything beyond inanities on a cellular network. And if you are going to use a WhatsApp voice call, it's pretty encrypted and it's quite good, but my friends in the national security establishment tell me that if you really truly want to be secure, you shouldn't be either on WhatsApp or on something like Telegram. Perhaps something like Signal is better suited for encrypted conversations. Traditionally, the balance between security and privacy was enshrined in pre-internet era. I use the US quite a lot, as it, in my opinion, stands for the gold standard on many of these issues, whether it is free speech or whether it is managing technology for these individual rights that you were talking about. So pre-internet, if a government wanted to wiretap somebody, they needed to get a magistrate's warrant to do so, whether the person was a drug smuggler or a terrorist or anybody. Post 9/11, it's a totally different story, but the basic principle more or less still remains, because you do not have weeks to monitor potential terrorists who may be using one of these encrypted services to plan attacks. So what happens today, and this is a lesson for those of us who are evolving policies in this part of the world, is that governments, including governmental agencies in the US and the UK and other democracies, let alone the non-democracies, but I'm talking about the democracies, they monitor metadata. Billions of conversations, billions of SMSs and texts, billions of social app postings, where at the first instance, privacy is not breached. But within certain narrow definitions, if prima facie reason emerges, then privacy can be breached, then there are rules in place. So one example I use a lot is, if an Indian agency were to monitor all the telephone calls and all the texting and all the social media apps without breaching a person's privacy, I'm okay with that. If then you find out that from a particular address or a particular IP address or a particular cell phone, the example I use is if the term RDX comes up very frequently. It's an explosive used quite a lot by terrorists. You and I might have queries about RDX a few times a week out of interest. But if somebody is querying or talking about RDX 5,000 times a week, perhaps that constitutes prima facie evidence to drill down and find out where that IP address is or who owns that telephone. But even then, there should be checks and balances. You may not have the time to sort of take weeks to take a warrant and go and do that, but there should be certain algorithms and protocols approved by law which should permit you to breach the privacy of in those specific cases where prima facie evidence exists. Now, over the last 20 years, what has happened is with the advent of the internet, we have voluntarily, billions of us, given up privacy by using social media, by using apps that we download without giving our consent, without reading those long agreement forms. The binary there is not privacy versus security. It is privacy versus convenience. We've done that for convenience, but ultimately it does lead to security risks as well. This conversation has become very prevalent in India in the last few years. And I moved a bill in Parliament because I supported Aadhaar, which is our biometrics identification system. And yet, I also supported strict privacy rules. Because if you want complete privacy of the sort that certain people want, certain very idealistic activists, then you can't live in the 21st century. You'd have to live in Westphalia. You'd have to live in the 15th, 16th, 17th centuries. You cannot today go through airports and say that I don't want that kind of invasive security, because there are real risks to people breaching airport security. And it's not just body scans. Today, you have more and more airports introducing facial recognition from the CCTV cameras. And they aren't even seeking your approval. They aren't even saying, please step up and be scanned. As you walk through the airport, you will be scanned. Your face will be recognized against databases of billions of people with the intention of weeding out terrorists, but you will also be going through that system. This is already happening in cities around the world. You have CCTV cameras to manage traffic, issue traffic tickets, and yes, also increasingly, not just recognize your number plate, but recognize you behind the wheel. Now, these are conscious choices we have made as a society. So my bill went through this quite a lot, consulted a lot of people like ORF and industry, and activists and users. And I'm very, very gratified that the two major Supreme Court rulings, which happened last year and just last week, have almost exactly come down on the line of what I have been advocating. I've been advocating that privacy is a fundamental right, and the Supreme Court interpreted the Constitution to say exactly that, as my friend Manish just said. But I also said that the state has a legitimate interest in very narrowly defined cases to breach that privacy. And the Supreme Court has agreed. The Supreme Court has agreed that there are 5 areas in which privacy can be breached, but they cannot be used wantonly. They cannot be used whimsically. They must be very specific and narrowly defined. So in conclusion, I would like to say this. As a member of parliament, I used to conduct audits every quarter, as all members of parliament are entitled to in their constituency. And each of our constituencies is like a small European country. Every audit I ever conducted of a government school showed up to 40% fake students. 20% was the bare minimum fake students, usually up to 40%. Why? Because then you can bill for non-existent students' uniforms, students' meals, students' books. It's the patronage system and it's corruption. Now, use of biometrics for deduplication of beneficiaries is something that the Supreme Court has specifically agreed to. Public beneficiaries, whether you're getting subsidized food or you're getting government, but they haven't agreed in the case of schools, but on broadly, the Supreme Court has agreed. What it has also said is that you cannot wantonly use Aadhaar for non-crucial parameters which they have framed in these 5 categories. So for example, banks were saying, if you give us your biometrics, you can open an account easily. Otherwise, the KYC norms, the know your customer norms, used to take several days. You had to give proof of address, proof of so many other things. The Supreme Court has said, sorry, you can't use Aadhaar for that. You have to go through the old process. There is this issue about whether the private sector is entitled to use biometrics or not. I believe this is a work in progress. It will evolve, because it would be weird to completely deny the private sector the access to the India stack that is being developed. But what will happen ultimately is that these narrowly and very strictly defined exceptions will apply to both government and private sector. And as my bill had proposed, there will be strict obligations for those who handle our data, those who process our data. Consent will be a requirement. But to believe that there must be an absolute binary between privacy and security is just not realistic in the 21st century. So we must agree to what exactly, where exactly will we agree to narrow breaches of privacy, and within what contexts, and who is authorized, what are the checks and balances for that. That, I believe, is the work ahead. Thank you.
Great. Let me now invite questions, and please use the mic in front of you to ask questions, and if possible, direct them to a specific speaker. And while you are, okay, all right, please.
Hello, this is Sandeep Oberoi from TCS. My role is to deliver cybersecurity services to our customers globally. My question is one of practicalities, where the rubber meets the road. The problem is the problem of scale. What we think of as a seamless internet actually underneath is operated through a large ecosystem of telcos, service providers, and so on. So the scale is something that is likely to create problems because these laws come with liability. So do you think our standards are keeping pace? Do you think there is a role for standards to make these regimes work? And if there is a role for standards, do you think the standards is keeping pace?
I'm actually going to request Joanne perhaps to handle some part of that question, which is on the issue of standards. Because I know Singapore has, for instance, been considering adopting a certain set of standards for cybersecurity. What could you please tell us? Of course, the issues of scale, and that is another matter altogether. But perhaps could you let us know what are some of the steps that Singapore has been taking on this front?
Right, so we have recently just passed the Cybersecurity Act in February this year, and then it's come into force in end of August. And a part of this Cybersecurity Act is the protection of critical information infrastructure. So as a part of this framework is that we require the owners of critical information infrastructure to adopt certain standards that are essential for cybersecurity. I think the issue of standards in general is a complex one, because the needs of every business, every system are different. The cybersecurity is a trade-off between cost, usability, and security. And if you were to mandate a set of standards across the board, you're only giving consideration to perhaps a particular setting of these three for your standards. So the Cybersecurity Act's approach in Singapore is a reflection of a risk-based approach where we have decided that certain types of systems are considered critical. And so for these, we will mandate a certain level of standards. But ultimately, it is up to the system owners to assess the risk case for themselves and the risk appetite that they wish to take for it. So I think mandatory standards should be used with a lot of perhaps caution and consideration before you apply it. It's quite heavy-handed. And I think as a part of it, it's also important to have a multi-stakeholder approach. So for us, we have 11 sectors that supply that supply essential services under the Act. And we work with sector leads within, who are government agencies who look at each of these sectors. And these sector leads could be regulating the sector. For example, for banking and finance is the Monetary Authority of Singapore. And they're regulating the sector as a whole. And we work through these partners because they understand the business case, they understand the sectoral context. And across the 11 sectors, there's a wide range. You have sectors that are very advanced in their cybersecurity awareness and practices, so banking and finance would be one of them. And then you have those that maybe are completely new to them, and there are also different sectors with different types of systems, like you have the operational technology, which is where you link it up to something that does something physical. So for example, it's often in the water or energy types of sectors that they use a lot of operational technology, as opposed to, say, ICT, which is more purely digital in nature. So we need to work with partners who understand the context of that particular sector and business. And even within the sector, there will be a variation where some system owners might have different needs from others. So I think I think it needs a more nuanced approach, and so this is the Singapore approach to it.
Thanks. Mr. Panda, you have.
I think it's a great question. I've dealt with this in Parliament and elsewhere. Scale really imposes some new challenges. So I'll cite two examples. So one is regulations hurting innovation. So if you have a requirement for certain cybersecurity compliance, a large tech company can handle it, but a startup cannot afford to have a compliance officer. You need to have certain flexibility. Perhaps a group of startups could afford to hire a compliance officer to meet certain requirements. So this is one example. Another example is, now many startups have no revenue stream. Their only revenue is selling your data. Now here, this imposes a certain challenge for policymakers. Now some of the big social media companies have become like utilities. So if a big social media company says, give me all your private data, otherwise I will not give you service, regulation, in my opinion, should prevent that. Because if you become like a utility, your service has to be accessible to every citizen. And it should not be that you must insist on private data. Whereas if a startup says that, look, I don't have any revenue stream, will you please voluntarily agree to give me your data so that I can give you my service? And if you're an innovative enough service, the only option is give me your data, get service, otherwise don't. But if it's an innovative enough new startup, I believe that regulations should provide that option. So scale does pose certain very, very interesting challenges.
Thanks. Deepak?
I'm Deepak Maheshwari. I head government affairs for Symantec, a cybersecurity company. So my question is about the recently approved standard. We are talking about standard called Transport Layer Security TLS 1.3 by Internet Engineering Task Force. Now this is something which provides, of course, end-to-end encryption. So on one hand, it's great for individual privacy in terms of privacy of communication, everything, and for data in transit. But on the other hand, it does impose a lot of challenges for law enforcement as well as for enterprise security. So what are the solutions that are coming forward in that space in terms of policy? So that's the question. Thank you.
Mr. Tewari, can I draw, without notwithstanding the technicalities of the new standard, but when you were in government, what were some of these concerns and how do you think have they changed with regard to new technical standards that have been developed? For instance, if I can paraphrase Deepak's question, WhatsApp is now a mass market phenomenon. There is, and with WhatsApp being a mass market phenomenon, end-to-end encryption is also a mass market phenomenon. So while I agree with you that perhaps every state, no matter which political party in power, has a regulatory impulse to control everything for whatever reason, how do you manage this challenge of new standards coming in which allow, as our title says, people to go dark? while meeting the legitimate needs of law enforcement?
So the question is that what are the legitimate needs of law enforcement? So let me take you back to almost the pre-internet era. So there was a time in India when law enforcement agencies could tap your telephones at will. So there were no regulations in place. So if they decided that they didn't like your face, they could kind of just decide to listen into whatever you said. 1998, the Supreme Court laid down guidelines saying that there is a process that you have to go through. In case you want to tap somebody's telephone, it cannot be an open-ended warrant. It can be only for 3 months or 6 months. And later on, they were engrafted as the interception rules into the Telegraph Act. So I think Jay has answered that question in his remarks. You see, ultimately, where there is a legitimate law enforcement reason to access data or to break encryption, and you have agreed rules of engagement with regard to information sharing in place, you can in fact do away with a lot of these data localization and other issues. The question is, what is legitimate? What is that acceptable burden of proof which would then mandate that even a private internet company, or let's say a utility as Jay defined it, will have to mandatorily share information. So I think that's the kind of conversation that we must be having, or we should be having, that in case you really want to access somebody's private data, what is the minimum threshold, what is the bar that you'll have to surmount?
On that issue, actually, let me ask this to both our politicians in the panel, and this is a phenomenon unique to India and less so to Singapore. It's fine to talk about a legal standard that law enforcement agencies should cross a certain threshold before which they can access data. But let's take the example of widespread rumors that lead to, as you know, instances like lynching. As things stand, law enforcement agencies in India have relied on this loophole, which is that WhatsApp messages are backed up on Google Drive by default, which is not end-to-end encrypted, and as a result, they don't have to worry about this phenomenon at all. What if WhatsApp decides tomorrow that this backing up is no longer a default option, or any other WhatsApp, I don't want to specifically point at this company, then you're truly, the mass market that you have catered to have truly gone dark. Then you are dealing with an evolving situation that you need to quickly address. For instance, the 2012 rumors in Bangalore. In those cases, what is a legal standard, or are you perhaps suggesting to both of you, is there a dynamic legal standard based on the scenario that you are faced with?
Our legal and regulatory environment suffers from many legacy issues. So for example, when Manish was talking about the 1998 Supreme Court judgment about requirements for wiretapping, even today, unfortunately, those checks and balances are minimal. It's really only an additional secretary of government signing a piece of paper. It doesn't go to a magistrate. It doesn't require to be met to meet a certain set of standards.
True.
So I think this issue, the question is a little bit moot until we take care of many of these old legacy issues. The Telegraph Act itself is from not 1 but 2 centuries ago. So we need to take care of, we have many aspects, and not just about privacy and national security, but many aspects of our, not constitution, the legal environment has British era rules which are simply out of place. And they gave the executive almost untrammeled authority for these things. So some of them have changed. We've got regulatory boards in place for many different aspects. So, but this aspect about compromising privacy is still really entirely within the executive. Just an additional secretary has to sign. We need to introduce these changes before we can expect that no matter what the law, that a certain standard will have to be met before that is applied.
I guess just to follow up on that, if you were to move it, say, from an additional secretary to a judicial magistrate, ensconce it in the judicial order, do you feel that the judiciary perhaps has the skills to respond to an evolving situation? Are they able to grasp the technicalities, or at least what's happening on the ground?
Well, you can have specialized courts, which are appropriately trained and skilled in order to deal with it. But, going back to the question that you specifically asked about the 2012 situation. Right. And so we had a situation in India where there were rumors in the southern part of India with regard to people from the northeast, which actually produced an exodus, and it created a huge humanitarian, if not a law and order crisis, to put it mildly. So what was our response? Our response was very simple. Shut the internet down. Right? And so therefore, since the state has not really invented or come up with a toolkit to deal with these situations, you deal with it in the most ham-fisted manner possible. For example, we shut the internet down every second day in Jammu and Kashmir, whenever we have a security situation. So as Jay was saying, we need to really come up the learning curve and see as to how we can put checks and balances in place, where if there is a compelling national security requirement, you can then possibly have a breach of those privacy requirements. But then again, you see, the thing is, in the absence of a global treaty arrangement, which allows data sharing or information sharing in almost real time, you will keep having this reflex from the state that there must be localization. So therefore, we must have it in a server which is located within our territorial domain. Now, the difficulty with doing that is it's not about public trust in government. It's about the kind of people in government. So therefore, if you have people who tend to have a very robust approach to national security, and who do not believe that privacy really matters, like the guys we have in government in India at the moment, then there's a difficulty. But if you have, a more enlightened regime, then possibly, you can sort of live with the data localization. But then, as I said, you see, establishments and bureaucracies going across governments have this instinct to try and get things under control. And when you have that instinct, the possibility of abuse and misuse is very great. And so therefore, I think the only real solution is a multi-stakeholder data sharing agreement, which over a period of time can really start operating in real time.
Great. Let's now take two questions at a time, since we are almost coming towards the end. Yes.
Okay. Good afternoon. My name is Erica Dia Basu from the American University in DC. My question, just quick two-pronged question. One, do we need to have in today's era this kind of binary between security and privacy, as if you have security, you don't have privacy, and if you have privacy, you don't have security? That's part one. And part two is, while we always seem to equate national security with strong kind of legislation, strong regulatory frameworks, is it possible that the reason why we look for strong privacy controls is because that's what our democracy is kind of founded on principles of free expression, and it is in our private spaces that we can truly be free? And so if we don't protect that, more than just an individual aspect, there's a societal cost we pay in terms of being a true democracy.
Thanks. So that's an interesting question, and we'll get. Is democracy founded on private spaces? It seems counterintuitive, but that's one question. Case.
Yes, I think it's fortunate that we have government officials and also legislators.
Recovering government officials.
Yes, exactly. The U.S., the President Trump signed the Cloud Act, which will facilitate cross-border data sharing among government agencies, which will also have implications for users' privacy around the world. So my questions to the panelists is if whether you will support your respective governments, Indian governments or Singaporean governments, to negotiate with the US to become the partner countries sharing the data among investigative agencies. So that's the question.
Thank you. Let me start from the right. And the first question which Dia asked is, I mean, it's a more philosophical, perhaps political question, but something that we should be talking about. Is democracy founded on private spaces? And if it is not, then why are we trying to regulate, or at least getting into this habit of regulating privacy?
So like I said earlier, I think it is not a binary, not just a binary at least, between privacy and security. I've made a case, I thought, that it is as much a binary between privacy and convenience, which we have been, for convenience, we have been just mindlessly giving up our privacy to both government as well as large private tech companies. But to believe an absolute standard of privacy being a requirement for democracy would work in a 17th century democracy. But in a 21st century democracy, there must be narrow exceptions. Again, let me be very, very clear. If you want that absolute standard of privacy where you can live like a hermit, you wouldn't be able to live in the 21st century. If you don't want to use Google Maps, if you don't want to use Uber, you don't want to use airport security, it becomes very difficult. But that does not mean that it's a binary. It does not mean that governments or big companies should be able to wantonly invade our privacy. That's why there must be very narrow and very specifically defined exceptions. But we will need those narrow and specific exceptions.
Manish?
No, I completely agree with your statement that democracies are based upon the premise of protecting private space. And I think the American Constitution is possibly the best example of that, whereby, according to me, erroneously, the right to bear arms is still being held to be sacrosanct, despite all the school shootings which have taken place and all the other massacres which have taken place. At one level, it looks completely ridiculous, but at another level, it's a huge assertion of the fundamental impulses which went into founding the American state. And I think the conflict came with the Patriot Act, the conflict between civil liberties and national security. And so therefore, at that point in time, when the Patriot Act went through, post 9/11, people were willing to sacrifice civil liberties or private space for what they thought was larger national interest. And the difficulty is that over a period of time, the intent does not always remain kosher. While at a particular point in time, it may be germane to sort of sacrifice your civil liberties, but then once you make that concession to governments once, there is no going back. And it's very difficult to roll the clock back. So I think you need to be extremely careful. And that's why when and I've been a long-standing critic of the Aadhaar program. And I think though it was unrolled with the best of intentions and it had a greatly empowering impact, but it was never explained to people what they are giving up for what they are getting in return.
Joanne, would you perhaps be able to also address the question as to whether data sharing agreements have worked at all in the case of Singapore? I don't know if Singapore has those sort of arrangements.
So the Cybersecurity Act does provide for particular types of cybersecurity info to be shared. Data sharing in general, I mean, it's a broad topic because, like, what kind of data are you talking about? So, yeah, I can only
Under the
speak
Cloud
on-
Act, just to follow
For
up,
the
it would be-
Cloud Act, if I'm not wrong, okay, it doesn't come under my purview, but if I'm not wrong, it's about it's scoped to serious crimes, if I'm not
Yes.
wrong. So evidently, it'll be my colleagues in the Ministry of Home Affairs probably who will take a look at that. But in general, those would probably be under. It's very tightly scoped, and I think it will be a matter of like discussion between the two governments.
Right,
yeah.
thanks. And just to follow up on Park's point, the Cloud Act essentially came out of this need to have a data sharing agreement with the UK. So if you are part of the Five Eyes arrangement that the United States has, then perhaps it is easier to get into the fold. But the question is whether countries on this part of the world would want to enter into that sort of an intelligence sharing arrangement and see that as a trade-off for much needed data sharing. But let's take these two questions and then close the session.
Thank you. I'm Liliana Petsova-Ilieska, Center for Internet Development and Good Governance, Macedonia. I have worked 10 years in the Ministry of Interior, previously police officer and to the rank of the International Cooperation, and 5 years in Data Protection Agency. So I have both sides of the coin, I believe so, and it's constant conflict whether it is security or privacy. So just a short history. In 2014 in my country there was a mass interception of communication as a scandal, and it led actually to publishing the intercepted conversations on YouTube. Basically, Prime Minister, ministers, government was intercepted, and those phone calls were published on YouTube. What led to change of government, because those conversations were mostly, we heard about corruption. So it wasn't about national security, but basically it was the corruption content. So my question is, and until now, we don't have any case before the court about privacy concern of the persons involved in this content, although it was not only official talks, but there were some private talks published on YouTube. So my question would be, up till how, until when you can publish, because every time the new government wants to reach something for their points, let's say, they publish something from before. So they have those previously intercepted communications. Until when we can use those intercepted communications, because there was a certain part of privacy within the content of the conversations. So how to prevent further processing of these data sets, this metadata that you could, not only receive, but you can hear from it, because it was not only corruption, but also economic data. And these intercepted communications were further sold, through the dark underground, let's say, ways.
Great. So I mean, it's
So
something that.
Yeah, and we had good regulations. So basically, are we speaking now, instead of security versus privacy, are we speaking of accountability within the law enforcement, the national security, the surveillance sector, or can we say that should we increase the transparency within these sectors?
Yeah, so let's get a response to that. Essentially, the question is, once data is collected, we always talk about thresholds by which law enforcement agencies have to collect data. But once it is collected, what is the shelf life, and what is it put to? And
But
when
when the goal was to change the government and to see that the corruption is ongoing. But when the goal is, achieved, can we reuse, republish those data? Because when, republished data is again seen as a processing of data. Until when we can use and reuse this data?
Yeah, I think Joanne.
And
Yeah.
not to be seen as a privacy
Got it.
breach. Thank you.
So I think it's a matter, I'm not sure about the context in which that incident happened, but I think it's a matter of legal design. Like in terms of how we approach the info sharing part of our Cybersecurity Act, the purposes for which the data is being used is very clearly stated in the Act. So you have to use it for only those purposes, and it's also mainly technical in nature and it's nothing to do with like privacy. And on top of that, if you misuse it, officers will be prosecuted. It's a criminal offense to misuse it. So I mean, I think it's how you design your legislation framework.
Yeah, so I tend to agree because after all, interception must have been carried out under a legal mandate.
Right.
And the legal mandate would have specified as to what is the apprehension which is triggering off this particular surveillance. And the surveillance is then limited to that particular purpose and should ideally be only used in a court of law to establish that particular crime. But more often than not, what then happens is that data finds its way, or those conversations find their way into the public space, and if they are legitimately intercepted conversations which have found their way into the public space for a purpose other than for which they were originally became the subject of interception, then the officers responsible need to be held accountable, and they need to be prosecuted for that. But having said that, there is another bigger problem. See, the other bigger problem is that, well, every third joker in this country is recording every conversation which he's having with somebody or the other, because you have built-in recorders into every phone. So what you think is a private conversation may ultimately turn out to be a very public conversation. And you see, when you had the initial opening up of the telecom space in India way back in 1996-97, I remember, you had a lot of these dark companies, you know, who were regularly selling call data, call records and SMSs, you know, to whosoever was interested. There was a thriving grey market in it for a very long period of time, till I think people got over their voyeurism. So there are many dimensions to this, but I think a very strict standard with regard to reuse of legitimately intercepted data needs to be put in place.
Let me respond with two sides of the coin. First, the reverse. Most countries have some statute of limitations for opening up old records. In the US, mostly after 30 years of confidential government records, they can be opened up. In this country, we are still arguing about the records of the death of a famous freedom fighter 73 years ago. And different standards apply in companies, in taxation. In some areas, 8 years of records need to be maintained. In some areas, 20 years of records need to be maintained. I think it'll depend on countries and a national debate as to what should be a period of confidentiality. Now the reverse. Till how long can data be used before it is forgotten or before it is deleted? So one classic example is, let's say there's a convicted pedophile who, after his conviction, is out, and this is a live debate in the US actually. If he were to be staying in a certain neighborhood, should his past record be erased because he has served his time in prison? Many parents would say no, that they deserve to know if a formerly convicted pedophile is living in their neighborhood. So this is a very, very live issue that I think communities and countries will have to discuss and decide what is appropriate for them.
Thank you. Gail?
So I'm Gail Kent. I lead on global security policy for the Facebook companies, which obviously includes WhatsApp. I'd love to know how you see the debate on encryption has changed in India since the draft encryption policy was published and withdrawn 3 years ago.
Would either of you?
Well, not much specific to encryption alone, but as I mentioned earlier on, the whole debate about privacy has been on fire for the last 3 years. Many activists have been taking it up. Industry has been responding to it. As I mentioned, I had introduced a bill which was the only bill in Parliament for a year and a half. Subsequent to my resignation, a colleague of ours, Shashi Tharoor, has introduced a private bill. The government itself has come out with a draft government version of a privacy bill subsequent to the Supreme Court judgment last year, which is still in consultation. It has not yet been submitted in Parliament. Encryption is a subset of this bigger discussion of privacy. And as I said, it's not just one binary about privacy versus security, but also about convenience and about services to be accessed, linking it to bank accounts and so on and so forth. Let me cite one example. In India, there are about 20 times the number of taxpayer IDs as actual taxpayers. And the reason for that is, in a pre-digital era, many people and many organizations deliberately created multiple tax IDs just to evade taxes and to launder money. Now, what the Supreme Court judgment does is it entitles the government to link Aadhaar biometrics to tax IDs. So suddenly, about 80% of tax IDs will vanish because they will be deduplicated. They will become one ID. So those people who are avoiding taxes or laundering money by distributing the money across various IDs will no longer be able to do so. So is this a breach of privacy? Not really. It just ensures that you are not able to get away by breaking the law of the land. But in terms of encryption specifically, the debate hasn't really been on the boil. It's mostly about privacy.
What's changed in the last 3 years is that if you decide to monetize the WhatsApp service in India, you'll actually earn billions out of it, because nobody talks on a regular phone any longer. There is this specter of terror and intimidation which has been institutionalized, that the big brother state is listening into everything. And so therefore, WhatsApp and its various other variants have become the normal mode of conversation for people who are having the most inane and innocuous conversations also. You know, not essentially any conversation which has any sensitivity attached to it, because generally I think people are chary about other chaps listening into, you know, what they may be talking to their spouse or to their family or to their business associates. So I think, as Jay was pointing out, encryption is really a subset of the larger ecosystem issue which has come up in India as to how much will you allow the state to transgress into your private space. Can the state transgress into your kitchen? Can the state transgress into your bedrooms? Can the state transgress into your communication space? Because what you've seen is a whole-scale transgression of the Indian state into the private lives of people. And that's why there's been this huge pushback, which has been led by the judiciary to ring-fence what is essentially the freedom which any individual, at least in a democracy, should be entitled to. I think that's the...
Great. Now let me close this panel with a question, a short question to the three of you, which is, and this sort of dovetails with Gail's question as well. We had a panel yesterday at CyFy bringing together a group of constituent stakeholders from Russia, and we talked about the interesting development that happened a few years ago in Russia, which is that the Russian parliament offered a draft bill on the right to be forgotten. It was an interesting case, given that Russia famously forgives but does not forget, and here was a country that offered a draft variant of the right to be forgotten. And one of the hypotheses that was offered was that the Russian MPs in the Duma wanted to be forgotten, and therefore the draft bill had this provision in place. My question to the three of you, based on your experiences in and out of government, is what do you feel about a right to be forgotten, given the wide range of political and philosophical and legal and technical issues that we've covered today, and the scope of the applicability in the country that you represent?
So I just spoke a little bit earlier about using an example of a convicted pedophile who might wish his record to be deleted because he has served his time in prison, but parents of that locality may not feel so. Today, if you look at the US Supreme Court nominee Brett Kavanaugh certainly wishes that his past had been forgotten. Perhaps we ought to have some kind of a standard to be met. You know, should your traffic violation be forgotten after 20 years? Absolutely. But some of these other examples that I've cited, should the public or should parents in your neighborhood have a right to know about your criminal past? Perhaps. So I think we need to find a line in the sand we need to draw, which certainly gives you the ability to be mostly forgotten for trivial or not so major violations in the past. But there may be reasons where, communities will want, insist, countries will want and insist that certain types of records must be there for a much longer period.
No, the question is that do you have a right to disappear from planet Earth if you choose to? And I think everybody should be given that right. Of course, it must be subject to certain reasonable restrictions, as Jay was pointing out, that if you have an extremely heinous criminal record and stuff like that, that obviously puts you into a different category altogether. But if you are a kosher citizen who does not want to live in a wide or a networked world. For example, I know of a lot of youngsters who've actually switched off from social media because they find it to be extremely intrusive. So I think the right to forgotten is a legitimate right. It's a subset of the right to privacy, and it must be actualized. But on a lighter note, the Russians have different ways of making people history.
So I think this particular right to be forgotten has to be put in, maybe in typical Singaporean fashion, in a wider context of with rights comes responsibilities. So if you were to just look at the spectrum of, in terms of data and people's preferences or desires with regards to their data, it's a wide spectrum. There's no absolute standard that even individuals would agree on with regards to the data, and there are different categories of data. Just as an example, and maybe more academic in nature, but when studies are done, it's shown that people are willing to sell different parts of, different types of data for even amounts as low as like 50 cents or $1, depending on like what the purpose is for and what they get in return for it. So in Singapore, there's a app that does ride sharing that was launched. It's called Tada, and it uses blockchain to allow people to monetize the data that they generate when using the app. So it shows that people are willing to sacrifice their privacy in exchange for something in many situations. And when it comes to national security issues, I mean, it's a public good. So people are reaping benefits in their day-to-day. In Singapore, it would be a very safe environment, a very stable environment. And I think that doesn't come without some kind of compact and trade-off, and I think it needs to be put in that context. Of course, we can work on policy or technical solutions to try to make the solution as nuanced as possible for each individual type of data or circumstance. Like, for example, in that app example, it was a case where if you had wanted to sell that particular data, you have different settings in the blockchain that you can choose based on your preferences. So I think the challenge could be perhaps distinguishing the different purposes and creating the right policy or technical solution to respond to it.
Great. Well, this has been a fascinating discussion. Let me apologize on behalf of Manish Tewari to our Russian colleagues in our midst. But the next time we are going to get a national security hawk, because unfortunately both the parliament veterans of parliament in our panel are progressive politicians, so by no means take this as the index of popular opinion in India. But on a more serious note, they have represented and reasoned out arguments on perhaps both ends of the spectrum vis-a-vis privacy and some of the concerns on national security. And we have had the advantage of listening to Joanne Wong from Singapore and bring the perspective of a country that has been able to make a lot of strides on both counts, on advancing privacy as well as developing a comprehensive framework on national security. So with that, let me close this panel, and please join me in lending a hand to our distinguished panelists.